Mr. President. Members, at this time, I move to suspend the regular order of business to take up and consider the committee substitute to Senate Bill number 9. Members, as many of you will remember, in 2021, the legislature passed Senate Bill 6, which I authored, and it addressed the release practices for habitual and violent offenders to better protect the safety of victims, law enforcement, and our communities. SB 6 presented one of the largest overhauls to Texas's bail system, and it drastically increased the amount of information available to judges when setting bail and enabling statewide data to be tracked on bail outcomes. Although we have made great strides, more must be done to ensure that judges and prosecutors have the necessary tools to protect public safety. The committee substitute to Senate Bill 9 includes several different policies to further strengthen our bail system. First, it requires hearing officers to make a no probable cause written finding in the record following a determination. We were finding that judges were making, or magistrates, a no probable cause finding with the prosecutors being unable to determine what they had done wrong, what was missing, why the decision was made. These will now have to be made in a written form. Secondly, it adds new information that will be included in the public safety report system. I've worked closely with OCA, DPS, and the Texas Department of Criminal Justice to ensure that our statewide criminal information systems have the capability to share pertinent information with each other. I will be offering a floor amendment to better assist these efforts as each system has different capabilities. To my dismay, I found out when we started digging into this that our different systems were not talking to each other. And we really need to bring ourselves up into modern times anyway, so we will be working on that. Additionally, the committee substitute gives the Office of Court Administration the sole discretion to modify the public safety report system to incorporate technological advances. Next, it mandates that the presiding judge, the elected judge, rather than a criminal law hearing officer, be the proper authority for setting the initial bond for a defendant on parole at the time they're charged with a new offense, a defendant who has previously has been convicted of 2 or more felony offenses, and a defendant charged with certain violent felony offenses such as murder, capital murder, aggravated kidnapping, and assault, and murder, I already said capital murder, aggravated kidnapping, and aggravated sexual assault. And a defendant charged with a felony who is also detained with a concurrent immigration hold. This change ensures that the most important bail decisions are made by judges who are elected officials and held accountable by their constituents. The committee substitute also provides additional clarification to the ex parte clear, which was a case in a district judge's jurisdiction to modify a pending bond set by our lower level magistrate. To build on past efforts, the committee sub amends the list of offenses that a defendant may not be released on a personal bond, adding unlawful possession of a firearm by a felon, violation of a family violence protective order, terroristic threat, and murder as a result of manufacturing or delivering of fentanyl. Additionally, it adjusts the reporting requirement for charitable bail organizations to be sent to the Office of Court Administration and increases transparency. It establishes a bond for a jailable felony offense may not be set until the defendant has gone before a hearing officer or judge. It also creates a new avenue for appeal when a prosecutor considers the bail amount insufficient to preserve public safety when a defendant is charged with a felony and has previously been granted bail for a separate felony offense. Lastly, for a secondary offense committed in a different county under Texas Code Criminal Procedure Article 17027, it clarifies that the county of the previous offense must be notified of the new offense within the next business day. Members, this is a pointed effort. This bill, it's been worked on a long time. It's focused, I'm going to remind everyone, only on violent repeat offenders. This bill does not alter the bond practices surrounding lower level misdemeanors or low risk offenders. The committee substitute to Senate Bill 9 empowers prosecutors to pursue public safety in the courtroom, brings additional transparency to the judiciary surrounding bail decisions on the most serious of cases. I want to thank the governor and the lieutenant governor for making these bills priorities. And again, this is a continued effort to protect public safety and the citizens of this state. I move to suspend.
Senator Hinojosa, for what purpose, from Hidalgo?
Well, Senator, how about you for some questions?
Yes.
Thank you, Mr. President. And as you know, for many, many years, we have struggled with our judicial system in that we had judges who were setting bonds without having the proper information on the defendant that was before the judge.
Correct.
As a consequence of that, many times we're letting people out on PR bonds that were already been convicted for another felon, or even out on parole, or another bond for committing another felony.
Correct.
And then we passed legislation, Senate Bill 6, I think.
Right, and that was in 21, actually.
2021. And anytime we pass major piece of legislation, we usually have to come back to sort of modify some areas to make it better.
Correct.
And Senate Bill 9, actually, the committee substitute Senate Bill 9 actually provides the judge a lot more information to be able to make an informed decision as to who the person is, the criminal background, and whether they're on parole, whether they are now on probation, or they are actually being convicted of another felony.
Correct. Yes.
So, and we actually ended up setting some guardrails for the judiciary as it relates to identifying those crimes for which they cannot set a PR bond.
Correct. And the bill, by requiring that the elected officials, the elected judiciary, make the most important decisions for the most serious offenders, it brings transparency for the public. We were finding that when the magistrates, many times they couldn't even read their signature on the magistrates, and there's no record of who had done it or when they did it or why they did it. And of course, this is very frustrating to the public and to the victims when they were trying to ascertain what had happened on specific bond situations.
And this should eliminate judge shopping, if you will, on some criminal cases. Instead of going to having a district judge who is accountable to the public, to the voters, set the bond, then you go to different magistrates or JPs. This will eliminate that part.
Right, and makes them they have to go before the judge to do it, yes.
And one of the things that's happening also, we actually identified, well, let me go back on those criminal cases where we do not allow a personal bond, that still can set up a bond to get out.
Absolutely, and there was some confusion on that. I was watching one of these talk shows this weekend, and there was misinformation, what a surprise, saying that we were setting no bond for felon in possession of weapon. That's not correct. We're simply saying you cannot get a personal bond. The judge still may look at, what type of felony it was, how long they've been on, on parole or off of parole, and they can look at all those factors in determining the appropriate bond.
And then we are also making sure that if a defendant is out on bond, and that person commits a second offense, that person goes back to the same original judge that set the original bond, so that there wouldn't be any confusion to be proper follow-up on a criminal case.
Correct. And if it happens to be in another county, then the other county needs to be notified that there's been a violation in an adjoining county or another county. And
we actually, in the bill itself, allow counties to have their jail management system and the court case management systems be part of the public safety report system.
Yes.
At no cost to them.
Exactly. The state is supplementing many of the implementation of this bill, yes, many parts of it.
Well, I think these improvements are very much needed as we try to focus on violent criminal being bonded out, some very low bonds, and many times in the past without information as to who that person was or is. And the biggest challenge will be with people who are not in this country legally, where it's very difficult sometimes to get any criminal history on that person.
Correct.
So hopefully the SGR1 will correct that.
I hope so.
Thank you for answering my questions.
Thank you, Senator.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Do you yield, Senator?
Yes. Yes, sir.
Thank you, Mr. President. Thank you, Senator Huffman. Senator Huffman, first of all, foremost, you're absolutely right. We need to pass any law that we can to protect all Texans. Every law-abiding man, woman, and child in this state should know and have confidence that we're passing laws to make their state a safe place to live. With that said, I just have a couple of questions. I noticed that you added in Section 7 of your bill a list of new offenses. I think these are the new offenses for which a personal bond is automatically prohibited. I believe it's
Yes, correct.
And so in that section, one of those is a terroristic threat.
Correct.
And
correct.
I'm just, what exactly constitutes a terroristic threat? Just because I'm just wondering, the purpose of adding that list, is it to deter violent offender? What is the purpose of it?
Well, that particular addition was made, as I said, we worked a long time on this bill. We just didn't sit down and think, well, we'll just start adding, offenses for the heck of it.
Right.
We work with prosecutors throughout the state, victims groups who came to us and showed us instances where the personal bond system had been abused in cases where there had been, those types of threats. We added it to the list of, and sometimes they were getting multiple personal bonds, even though they would get out and then continue to harass and threaten individuals. And so we added that. No, this is very important to remember because, people will instantly say, well, that's not fair, or maybe a terroristic threat that's not as bad as another one. And I'm using quotes when I say that because that's all in the perception of the victim. But I would say that, remember, a judge still has full discretion to set any bond. So if the judge thought a $100 bond was appropriate, then they could certainly set that. They could set a $1 bond, I suppose, or they may choose to set a $50,000 bond because they're very concerned once they weigh all the factors that they're supposed to weigh under the law. So it was chosen as a personal bond because it is an offense that brings terror and fear, and it has a real victim. And at the request of prosecutors and victims, we thought it was a reasonable addition to the list.
Thank you. And so the good news is that you said a judge still has the ability to decide whether that threat was more, just I'm going to beat you up versus a threat that was very serious, something handwritten description of how they're going to hurt your family.
Right. I'm going to sit outside your house every night with, a loaded shotgun and wait for you to come out. I'll be sitting there, just watch for me. I mean, there can be very terrorizing terroristic threats.
Yeah, I know.
Again, it's kind of in,
No,
you have to look at the circumstances, but the judge still has full discretion on this.
And that's the important part. Thank you very much.
Yes,
Thank you for
sure.
answering my questions.
Senator Hinojosa from Hidalgo, for what purpose?
Just a quick follow-up question of the author.
Senator Huffman?
Yes, of course.
Yeah, I forgot to mention, Chair Huffman, that this is a real live event where in my Senate district in Jim Wells County, the defendant killed his wife, and he was let out of bond, low bond. So he got out on the low bond, and guess what? He went and killed his mother. So those are real life examples of what really goes on in our judicial system. If we as legislators don't take action to try to correct some of those abuses that have been taking place as it relates to violent criminals.
Absolutely. And tomorrow I'll have SJR 5, and we'll go through a bunch of those examples of absolutely horrendous facts where individuals have been murdered by individuals already out on bond, many times for murder. Unbelievably so, but that is the facts.
Thank you for responding to my question.
Members, thank you. The motion is to suspend the regular order of business. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton, Eckhart, Flores, Gutierrez, Hagendu, Hall.
There being 28 ayes and 2 nays, the motion is suspended. Chair lays out now on second reading, committee substitute for Senate Bill 9. The Secretary will read the caption.
Committee substitute Senate Bill 9 relating to the release of defendants on bail, the duties of magistrate in certain criminal proceedings, the regulation of charitable bail organizations, and the notice provided by peace officers to victims of family violence, stalking, harassment, or terroristic threat.
Members, the following amendment. Secretary will read the amendment.
Floor Amendment Number 1 by Huffman.
Senator Huffman, you're recognized on your amendment.
Thank you, Mr. President. Members, as I mentioned in my bill layout, this amendment is intended to assist DPS, TDCJ, and the Office of Court Administration to collect new information for the Public Safety Report System. Because pretrial information can be collected at the county level, the amendment also directs sheriffs to help transmit any conditions of release to DPS. It implements a new data collection mechanism for failure to appear. The rate at which this information is collected around the state varies, but I think it's important for those who set the bail to have this information. So this will be a project to get this done, but we are going to be working on this, and it is something that the state needs to do, where all these different systems can talk to each other, to know when someone's released on parole, to know when someone has violated their probation. Well, there's one central repository. I would have thought that we would have had that by now, but we don't. So we will be working on that to get that accomplished, and that this amendment
Senator West, for what purpose?
facilitates that.
Question of my colleague. Senator.
Do you yield?
Yes.
Thank you, Mr. President. Is there any cost to the counties as it relates to this particular amendment, or is this going to be done at the state level?
I don't want to say there would be no cost to the county, because it would be unfair for me to say that, because I don't know. I will be say that I'm looking at this carefully, and I'm working with OCA, and I've asked them to tell me what cost it would be to facilitate this happening, and I'm working on making sure that's funded, which I think I can get done.
Are you in a unique position to make certain that the funding gets there?
I think with the support of the Lieutenant Governor and all 31 members, I can get this done. I'm counting on my members to support me on this.
I too already thought there was an integrated system, but there's no integrated
Isn't that
system.
surprising? Yes.
It's very surprising.
So it'll probably be an interim project, but we're going to work on it.
Thank you very much,
Okay,
Mr.
thank
President.
you.
Thank you. Senator Huffman moves adoption of the amendment. Secretary will call the roll. Or is there objection? Hearing none, amendment is adopted. Following amendment, Secretary will read the amendment.
Floor Amendment Number 2 by Huffman.
Senator Huffman, you're recognized on your amendment.
Thank you. Members, this amendment is hot off the press, and it is trying to fix an issue that is occurring as we speak in Travis County, where a defendant who was alleged to have committed murder was just released on a $100 bond and is free in Travis County. The issue is that the judge believes that because the individual was not indicted within 90 days, what was later indicted, I think on like the 92nd or 93rd day, that the judge can't go back and reassess the bond now that the person has been indicted. So this amendment would clarify the law that yes, once an individual has been indicted and or not indicted within the time period and released, once indicted, the judge can go back and reassess the bond based on the new information. Hope that's clear, but anyway, I move adoption.
Any objection? Hearing none, amendment is adopted. The following amendment, oh, sorry, that's the last one.
Yeah, that's supposed to say that.
You're recognized for motion to engrossment.
I move passage to engrossment on the committee substitute Senate Bill 9.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
28 yes votes, 2 no votes. The bill passes to engrossment. You're now recognized for motion to suspend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell.
28 ayes, 2 noes. The constitutional 3-day rule is suspended. The chair now lays out on third reading and final passage committee substitute for Senate Bill 9. Secretary will read the caption.
Committee substitute Senate Bill 9 relating to the release of defendants on bail, the duties of a magistrate in certain criminal proceedings, the regulation of charitable bail organizations, and the notice provided by peace officers to victims of family violence, stalking, harassment, or terroristic threat.
You're recognized on final passage.
Move final passage of the committee substitute Senate Bill 9.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
There being 28 ayes and 2 nays, the bill passes. And one of the moments I'm really proud of the Senate bipartisan support to protect the lives of adults and children in the state of Texas. Thank you, Senator. Thank you, members.